Hi everyone, my name is George and I'm the head of the Global Mobility and Immigration Division at Madison law firm. Today's video will cover quite a large amount of content, but we'll try to keep the information brief and informative. We won't be covering visa cancellations and instead we'll be focusing on visa refusals. The topic that we're going to cover today is the merits review process and when a Section 48 bar would apply. So the key recipients of this information are individuals who have been refused a visa onshore in Australia and are unsure what to do next. Many would have heard of the Section 48 bar or being Section 48 barred and not knowing or understanding what this means, so we'll do our best to help you understand. But first, let's cover merits review. So the Department of Home Affairs has refused your substantive visa application while you're in Australia and you're not satisfied with the outcome. You want to challenge the decision made. This is called applying for merits review. Generally, the department will provide you with the refusal notification and the decision record. Within the notification itself, you will be given a prescribed time frame in which you can lodge your application for review of the department's decision. In most cases, you must be in Australia when you apply for merits review, and if you don't lodge the review application within the prescribed time frame, then the validity of the review application will be questioned. You may be invited to comment on why you believe you lodged a valid review application, especially if it was out of time, because the tribunal might not have the jurisdiction to hear the matter. You don't want to be in that position, so please lodge your review applications on time. The prescribed time frame will vary, so you need to read the department's decision notification very carefully. It might be 7, 14, 21, 28 days or even longer. For refugee or protection visas, there is no application fee to review your case. But for all other reviews, the review applicant has to pay an amount to lodge a valid review application. You'll have to complete a review application online or as a paper application, and the review application will need to be submitted to the Administrative Appeals Tribunal or the Immigration Assessment Authority, whichever body has the jurisdiction to review your matter, and this will be outlined in the department's notification of the decision letter. For reviews of protection visas, the fee will be paid after in the event that the review applicant is unsuccessful. This is called a post-hearing fee. For other visa reviews, if you're successful, then 50% of the application lodgement fee is generally refunded back to the review applicant. The AAT or the IAA will undertake a review of the department's decision and might either affirm, which means they agree with the department's decision, remit, which means to change with a certain direction, modify, vary, or set aside the department's decision. It is important to note that the AAT or IAA is not bound by the decision of the department, but they are governed by the same legislation. Now we'll give you an overview of the Section 48 bar. So Section 48 of the Migration Act says that when an applicant has had their substantive visa refused or cancelled during their stay in Australia, an application for a substantive visa cannot be made while the applicant is still in Australia. And a substantive visa refers to any visa that is not a bridging visa, a criminal justice visa, or an enforcement visa. So some examples of substantive visas include skilled migration visas, sponsored working visas, visitor visas, or student visas. Those are substantive visas. Therefore, if you're in Australia and your substantive visa application has been refused or cancelled, and you do not currently hold a substantive visa, then you will be barred from applying for most substantive visas while in Australia. It is important to note that an invalid visa application will not attract a Section 48 bar. For example, if your substantive visa was not granted on the basis that the visa application was made incorrectly, the Section 48 bar will not apply to you. Now there are some exceptions. Those who are subject to this bar may still lodge applications for those visas listed in Regulation 2.12 of the migration regulations, and these visas include partner visas, bridging visas, protection visas, territorial asylum residence visas, border temporary visas, child residence visas, medical treatment visitor visas, retirement temporary visas, special category temporary visas, resolution of status visas, and investor retirement visas. It is important to note that additional requirements may be imposed on applicants who apply for these visas if they are Section 48 barred. If you're facing a Section 48 bar from applying for a substantive visa, the following options are available. You could apply for a review of the decision to refuse or cancel the substantive visa to the AAT or the IAA through the merits review process. Alternatively, you may leave Australia and apply for a substantive visa while offshore, assuming that you have not been excluded from making further applications. Or lastly, you could apply for one of the visas listed in Regulation 2.12 of the Migration Regulations as previously mentioned. This is a very complex area of the law, so if you believe you have or might be affected, please reach out to us through the contact details in the description accompanying this video. Thank you for watching. We wish you a wonderful day.